He has owned firearms for 15 years. Never a complaint, never an incident, never so much as a warning. His PAL is valid. His firearms are registered. By every measure that matters, he is exactly the kind of gun owner the system was built to trust. And he is also, right now, breaking the law every single night without knowing it. Not because of what he owns, because of how he is keeping it. This is the part of Canadian firearms law that almost nobody explains clearly, and it is the part that quietly turns more legal gun owners into criminal defendants than almost anything else in the entire Firearms Act. Your firearm being legal and your firearm being legally stored are two completely separate questions. And the gap between those two questions is where thousands of responsible Canadians get caught every single year. Here is how the law actually works, broken down the way nobody ever sits you down and explains it. If you own a non-restricted firearm, most rifles and shotguns, Canadian storage regulations require it to be unloaded at all times when not in use, and either secured with a locking device that renders it inoperable, like a cable lock or trigger lock, or stored inside a container, cabinet, or room that is securely locked and cannot easily be broken into. That sounds simple. Here is where it gets complicated. The ammunition for that firearm cannot simply be sitting next to it. If your ammunition is readily accessible alongside an unsecured firearm, you have already failed to meet the storage standard, even if the firearm itself has a lock on it. The law treats a locked gun next to an open box of ammunition as a meaningfully different situation than a locked gun with no ammunition anywhere near it. Most people never think about that distinction until it is the reason an officer is standing in their living room. If you own a restricted firearm, and for most Canadians that means a handgun, the requirements are significantly stricter. The firearm must be unloaded. It must either have a secure locking device attached or have a critical component like the bolt removed entirely. And on top of that, it must be stored inside a container or room that is securely locked and resistant to being broken into. 2 layers of security, not one. A trigger lock alone is not enough. A locked drawer alone is not enough. The law requires both, every single time that firearm is not in your hands. Now here is where this becomes a trap door instead of a technicality. Most storage violations are never discovered during a quiet afternoon at home. They are discovered during the exact moments when stress, confusion, or chaos is already happening. A domestic disturbance call, a wellness check after a neighbor's complaint, a break-in where police respond and happen to see how your firearms were kept. In every one of those situations, officers are not searching for a storage violation. They stumble into one because the firearm is sitting somewhere it should not be, the way it should not be. And the moment they see that, the entire legal conversation changes instantly. It is no longer about whether you are a dangerous person. It is about whether Section 86 of the Criminal Code has been violated, which is a separate criminal offense carrying real consequences, completely independent of whether you were doing anything else wrong that day. Transport makes this even more complicated because the rules change again the moment that firearm leaves your house. For a non-restricted firearm in a vehicle, it must be unloaded and it must not be visible. Out of sight, in a case, in a trunk, somewhere a passerby glancing into your car would not see it. For a restricted firearm, the standard is much higher. It must be unloaded, secured with a locking device, and placed inside a locked container. Not a soft case, not a backpack, an actual locked container. And that firearm needs to be covered by a valid authorization of transport for the specific route you are driving. Since 2021, your license gives you an automatic ATT for trips to and from an approved shooting range in your province, and for bringing a newly purchased restricted firearm home. Every other route requires a separate authorization from your provincial chief firearms officer. Drive somewhere that route does not cover, and the firearm being perfectly stored inside the car does not save you. The trip itself is the violation. Here's the part that should genuinely concern every responsible gun owner watching this. None of these violations require intent. The law does not ask whether you meant to do something wrong. It does not care that you are exhausted after a long shift and left the trigger lock off for one night planning to put it back on in the morning. It does not care that you have transported that handgun to the same range for 10 years and assume the same authorization still applied after you changed your route slightly. Storage and transport offenses in Canada are largely about the condition the firearm was actually in when it was discovered, not about what was in your head when you left it that way. And this is exactly why the protections you might already know about, your right to refuse a search, your right to decline consent, your charter protection against unreasonable search and seizure, collapse instantly the moment an officer can see a storage violation for himself. Refusing consent only matters when the police do not already have a lawful basis to look further. A visibly unsecured restricted firearm, a loaded gun within reach of ammunition, a handgun sitting unlocked in the vehicle. These are not searches at all. They are observations. And an observation of an obvious violation gives police everything they need to act, with or without your permission. So the real protection here does not happen at the moment of the traffic stop or the moment officers walk through your door. It happens the night before, when you put that firearm away. It happens every single time you decide whether the lock goes on, whether the container gets closed, whether the ammunition goes somewhere separate. That is the moment your legal status is actually decided, long before any officer is ever involved. Know your specific obligations for every firearm you own. Non-restricted and restricted firearms are not held to the same standard, and treating them the same is exactly how careful, responsible owners end up with a criminal charge they never saw coming. Check your storage every time circumstances change. A new firearm, a new vehicle, a new living situation. And if you are ever unsure whether your current setup meets the legal standard, that uncertainty itself is the warning sign. The firearm is legal. Whether the way you are keeping it is legal is a separate question entirely. And it is the one question most gun owners never stop to ask until somebody else asks it for them.